Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Today's topic is urgent and important for every Indian professional, especially those connected with US immigration. On 19 September 2025, President Donald Trump signed a presidential proclamation imposing a $100,000 fee for companies sponsoring foreign workers entering the US under the H-1B visa. This decision has sent shockwaves through the Indian IT sector, global businesses, and immigration experts. In this video, I will explain what the proclamation actually says, who is affected and who is exempt, whether this is legally valid and can be challenged in US courts, short and long-term impact on India and Indian workers, what Indian professionals and companies should do now. Let's begin. Part 1. What is the H-1B visa? The H-1B visa is a non-immigrant visa allowing US employers to hire skilled foreign professionals in specialty occupations like IT, engineering, finance, healthcare, and research. Every year, the US issues around 85,000 new H-1B visas, and Indians receive more than 70% of them. For decades, Indian professionals have used the H-1B route to build careers in the US, contribute to innovation, and support families. But now, this opportunity faces a significant new barrier. Part 2. What does the September 2025 proclamation say? On 19 September 2025, the White House issued a proclamation titled Restriction on Entry of Certain Non-Immigrant Workers. Key points. Effective from 12:01 a.m. EDT on 21 September 2025. Applies to H-1B specialty occupation workers. A $100,000 payment must accompany any petition for a foreign worker outside the US. If this fee is not paid, the petition will not be approved, and entry will be denied. The proclamation is valid for 12 months, subject to extension. This rule applies to both first-time applicants and existing H-1B visa holders who are outside the US and want to re-enter. Part 3. Who is affected and who may be exempt? The rule directly affects new H-1B applicants outside the US, H-1B visa holders currently abroad, seeking re-entry, US employers planning to bring in workers from India or elsewhere. But there are possible exemptions. National interest exception if the Secretary of Homeland Security finds that the worker or employer contributes to national security, economy, or critical infrastructure. Case-by-case waivers may apply to specific industries, projects, or individuals. However, the criteria and process for such exemptions are not yet clearly defined and are expected to be released soon by DHS and the State Department. Part 4. Legal validity. Can this be challenged? Yes, and very likely it will be. Several US immigration law firms have already announced their intent to file lawsuits. Why? Here are the major legal concerns. 1. Overreach of executive power. The US President cannot impose such a large financial obligation without explicit congressional approval. 2. Improper use of INA Section 212(f). This section allows the President to restrict entry for national security, but not to levy high visa fees. 3. Violation of Administrative Procedure Act. The rule was enforced without prior notice, without public comments, and without rulemaking transparency. 4. Discriminatory impact. Since most H-1B beneficiaries are Indian, this move may be challenged as discriminatory and a violation of equal protection. Therefore, federal courts may freeze or strike down parts of this order, especially if they find it arbitrary or unconstitutional. Part 5. How does it impact Indian professionals? This is where the impact is most serious. Indian IT companies may cancel or delay US projects. Startups and small US employers may stop hiring foreign talent. Many Indian H-1B holders stuck abroad may lose their jobs. Families on H-4 dependent visas may be separated or lose legal status. Indian students graduating in the US may find fewer pathways to work. This policy not only affects business, it affects livelihoods, families, and dreams. Part 6. Does it apply to people already in the US? Here's an important clarification. If you are already inside the US on a valid H-1B, this proclamation does not directly affect your stay or extension, provided you don't travel abroad. But if you leave the US and try to re-enter, the employer must pay the $100,000 fee for your petition to be approved again. So, travel becomes a legal risk for existing H-1B holders. Part 7. What will happen next? Here's what we can expect in the coming weeks. Multiple court cases challenging this proclamation. Petitions for temporary restraining orders or injunctions. Public pressure from tech giants and universities. Re-evaluation by DHS and Labor Department. Diplomatic reactions from India. India may raise the issue formally through MEAS and trade dialogues, especially given the impact on the Indian economy and diaspora. What should Indian professionals and employers do now? Avoid unnecessary international travel if you are on H-1B. Explore remote work options with US employers. Keep documentation ready in case you qualify for a national interest exemption. Employers should assess alternatives like nearshore or offshore models. Indian graduates should start exploring career opportunities in India, UK, Canada, or EU. Part 9. The bigger picture. What should India do? While this is a temporary disruption, it is also a permanent lesson. India must invest in retaining top talent, create globally competitive compensation, improve digital and research infrastructure, support startups, R&D, and innovation, strengthen diplomatic pressure where citizens' interests are affected. This is a chance to turn brain drain into brain gain, but only if we act decisively. Conclusion. The H-1B visa has symbolized Indian aspiration for decades. But with this $100,000 fee, the US has sent a clear message: we are prioritizing high-cost, high-skilled workers only. Whether or not this holds up in court, Indian professionals must prepare for a future where US immigration is unpredictable and expensive. It's time to focus on India-first solutions and global career alternatives. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.